Hello, good morning, and thank you everyone for joining our webinar on California's new data privacy law, CPRA. Consumer data privacy laws are evolving very quickly here in the U.S. Not just CPRA, but the federal data privacy legislation that's making its way through Congress, the ADPPA. So we're very excited and looking forward to talking about the most restrictive legislation so far here in the US and answer questions like, what is CPRA? What changes will affect my company? What are the potential risks of CPRA? And what should I be doing now to comply and prepare for it? My name is Chris Byrne. I'm the VP of Sales for North America for Didomi, and I'm excited to welcome and join Todd Ruback and Jeff Wheeler in the discussions. Todd, Jeff, if you want to take a moment to introduce yourselves.
Yeah, thank you, Chris. It's a pleasure to be on this panel and speaking with you and Jeff Wheeler today about what we know so far about the CPRA. I'm looking forward to this conversation. But I am a managing director at FTI Consulting. I'm focused on, which is a consulting advisory firm, and I sit in the information governance, privacy, and security team based in the New York City area. And my focus is specifically around or at the intersection of privacy, advertising, technology, and digital advertising. I've built out an ad tech center of excellence, just specifically focused on helping companies solve vexing, difficult regulatory issues and problems arising from the emerging laws that we're going to talk about.
Great, welcome, Todd. Jeff?
Yeah, I guess my turn, right? So Jeff Wheeler, I'm the head of product here for North America at Didomi. I've been in the privacy space for a little over 7 years now. I've spent quite a bit of time working with multiple technology solutions, building out different CMPs, DSAR solutions, and also just working with multiple companies identifying like their third-party trackers and general data governance in the privacy space. Great.
So welcome, guys. So just some house rules for the webinar here. We want to keep this, open discussion, an open forum, not just a presentation. By all means, feel free to use the chat box and ask questions on the fly. We'll be happy to answer them. We also want to keep it interactive, so we're going to conduct a couple polls, and there may actually be a pop quiz in here or two. So be prepared, and no Googling allowed. So with that, just a quick overview on again, Didomi. So Didomi is a Paris headquartered global technology provider. And what we do is we help companies basically put consumer choice as the core of their strategy. So, what does that mean? That basically means we offer technology that produces and offers a consent management platform that helps process consumers' privacy preferences, as well as a preference management platform, or PMP, that helps process consumers' preferences. And, we think that privacy is a fundamental human right at Didomi, and that, consent-based consumer choice should be the guiding principle to better foster trust and transparency among consumers and brands. Todd, you want to tell us a little bit about FTI?
Sure. So yeah, FTI is a consulting firm, close to 7,000 people strong, publicly traded on the U.S. markets. We've been around since the late or mid 80s, I should say, and our start really was around e-discovery, and that's still our core service offering. But since our inception, we've added service offerings, mostly around advisory services to help large organizations and law firms in different areas, whether it's corporate restructuring, data governance, information governance, security, InfoSec, and now privacy. Our privacy team has between 40 and 45 consultants, and we provide the full broad range of privacy consulting services. But as I said earlier in my introduction, I'm specifically focused on the Ad Tech Center of Excellence and our integrated suite of products that we just launched, I think last week it was. But back to you.
Yeah. Yeah, congratulations again on that. That's very exciting. So, let's just dive right in. So the first question is, what is the CPRA? Todd, I'll turn it right back to you. Tell us, what is the CPRA?
Good question. So look, even though I'm a lawyer, I'm not practicing as a lawyer. I'm a recovering lawyer. I'm, a privacy consultant at this point. So, please, leverage your counsel's definition of what the CPRA is. But, at its highest level, the CPRA is an amended version of the CCPA, right? And now we have 4 other state consumer privacy laws with the number, I think, 17 or 16 in the queue. And there is a common thread between them all. Number one is that they're inspired by advertising technology and the invisible data collection activity happening behind the digital curtains on websites and mobile sites. And they're not prescriptive in the sense of saying it's nefarious, this sort of data collection and use. But what they are saying is we recognize that this is a form of data that's being collected about individuals, and individuals should know about it. So there should be transparency, and individuals should have the choice to control whether this sort of data should be collected about them and shared. And there's nuanced differences between the different state laws, but that's the common thread. And it's really important for organizations to remember what inspired this law and the other similar state laws. The fact is that there is an emerging body or family of laws focused on ultimately advertising technology, and this opaque ecosystem is a statement and is indicative of which way the winds are blowing. So, I'm counseling our clients here at FTI to, as they prepare to future-proof and manage, operationalize how they're going to comply with not only the CPRA, but the different state consumer privacy laws, that they understand there's no one size fits all, but that ultimately, the aim here is to empower individuals, their customers, their consumers, with control. And although that will require a huge investment in cost and resources and technologies and process and change management, it will result in a very collaborative relationship ultimately with consumers. Mm-hmm. Now that's just, at a high level, but the details are what's listed on the screen, right? CPRA is coming into effect January 1st, 23, and as you can see from the center box, it obligates notice of data collection, as I mentioned, at or before when collection occurs, right? And there's some operational challenges that we'll talk about. And interestingly, as we're getting closer and closer to the European approach in GDPR, the CPRA introduces the concepts and regulatory requirements around privacy impact assessments data subject access requests, and uniquely dark patterns, which we're going to talk about, data minimization, right? Only collect what you need, and mandatory opt-out, as well as signal recognitions, industry developed signal recognitions. All very interesting, but confusing as well.
Yeah, it's a great overview, Todd. I think we'll touch on a handful of these, as you mentioned, including dark patterns. But we did get our first question. Thank you, James. He asked, "What is the main risk for companies that don't comply to the CPRA?" I know we're going to talk about risk a little later, but we can jump in and answer that. We know that there's audit risk, there's financial or economic risk of non-compliance. There's the especially for brands that devote a lot of investment to their own branding and being a good corporate citizen. There's name and shame for not being upfront, transparent, and trustworthy around their data collection practices. And then there's the potential operational and systems development risk. In other words, having to play catch up and get a solution in place to comply within the time frame, if without doing proper due diligence and finding the best solution. Jeff, Todd, feel free to add on that.
Yeah, and Chris, let me just add on to that. There's specific regulatory and enforcement risks that organizations are going to have to manage and against and mitigate. That means really dedicating resources, right, to make sure that you monitor your compliance with regulatory requirements. Now, the CPRA, in many of the situations, there is a notice period where a state attorney general will give you notice and a period to cure any perceived deficiencies, if you will, or gaps in compliance, I should say. But in addition to regulatory risks, it's really important to point out and underscore that where there is potential gaps between compliance, often it's a matter of process as opposed to a single event. And when you look at potential fines and penalties that each of the states can impose, in some cases it's like $750 or even $75 per individual per event. And when you're talking within the context of ad tech, which is a dynamic data collection ecosystem driven by third parties, that could be millions of transactions when you look at the number of users and the number of third parties that are collecting and passing information down the daisy chain. And then finally, an emerging risk that we're seeing more and more of is we're seeing a number of recent class action suits being filed, beginning in California, now in other states, but all quite similar, around wrongful data collection by third-party ad tech companies on websites.
Mm-hmm. Yeah, there's no question that the fines can quickly add up. Yeah, I think it's $2,500 for unknown infraction, $7,500 for known infraction, and then multiply that by, as you said, the ad tech multiplier could easily get up into the tens of millions of dollars.
Yeah.
Well, and I think the one important piece that we probably haven't addressed on that, right, is that's unique to CPRA and CCPA, if you will, is the private right of action. Mm-hmm. Right, we talk about the regulatory fine, but there's also what relates back to that end consumer trust and making sure that your visibility with the consumer is important, because now private citizens, to Todd's point, they can take actions in their own hands. And then on top of that, I think what's also interesting about CPRA versus even the other state laws and CCPA is the introduction of the CPPA, the California Protection Agency, right, which are now having more jurisdiction to actually enforce. Right, I think when you look at some, CCPA, when you've got an attorney general that has had historically, smaller office to enforce such a major law, that's also going to get lost into everything else they have to enforce. But now that you've got one single regulatory body that can focus on this to really put teeth into what CPRA is, it's given a lot more like oomph, if you will, into how CPR is going to be managed. And I also think this is also what's leading into what we're also hearing nationally with the Privacy Act, the ADPPA that was introduced in Congress. It's the reason I think that we're seeing like the FTC talk about the dark patterns, which we'll talk about here shortly. Right, they're following a lot of the guidance of what we're seeing in California and how that's going to be enforced, and really what the expectation I think nationally is going to be.
Yeah, so there are a couple questions around that. Doesn't CPRA have significant fines as well? And are they planning, are the California regulators planning on imposing those fines under CPRA?
Yeah, I mean, short answer is yes, and I can't speak on behalf of the California enforcement body, but I think there's pretty strong anecdotal evidence to date that that is their intention. They have been a few waves of inquiry letters that have gone out, signaling their areas of interest. So we can anticipate robust enforcement, and we should assume that there's already significant monitoring of potential compliance or non-compliance occurring.
Mm-hmm. Okay, so everyone, if you go to your polls, the polls tab, and enter in, we meant to do this before what is CPRA, but essentially we want to get a sense of what everyone's CPRA readiness is today. Have you ever heard of it up until this webinar? You've heard of it, but you haven't done anything yet to prepare. You've heard of it and are actively preparing for it, or you're just ignoring it until it becomes enforceable. So go to the polls, answer that first poll question if you would, and then we can get back to, so we were talking a little bit about dark patterns, and they've really become, front and center a little bit. We're hearing about them more and more in the industry as the draft regulations around CPRA are being discussed. So let's talk a little bit about dark patterns. What are they? So Jeff, I'll turn it over to you. I know that you've been pretty close to this.
Yeah, no, I think this is an interesting topic. It's obviously started in Europe, with a lot of the consent and cookie banners that we've seen in Europe. Max Schrem's group in particular has highlighted a lot of these. Really what we're talking about with dark patterns is from a UX perspective, right? From that user experience perspective of trying to get that end user to make the choice that you want them to, right? We could go into a lot more detail about what that is, but really when we're talking about consumer choice, and I think this is regardless of regulation, we want to make sure that we're talking about giving a consumer a clear and concise choice, right? So if you're doing things like highlighting certain buttons or only offering one button versus multiple buttons on a cookie banner, right? Those are what we're talking about in dark patterns, and it's really interesting seeing this becoming more and more of a topic here in the U.S. Like I mentioned a second ago, the FTC is talking about this. Obviously, CPRA is talking about this, and it's really highlighting really this idea of consumer and user trust. And if I were to even go back to the original question that we asked, what is the real risk of CPRA? Like, to me, that's the most important risk, right? It's your brand trust, and if you're not giving those clear, concise choices to your users, that's the risk. That's the biggest risk you have in terms of not complying with CPRA. I don't know, Todd, I'd love your thoughts on this, based off, who you're talking to.
Sorry, I was on mute. No, I mean, you've got it right. Like, it's really interesting. That's a great thing about privacy. It's always interesting, but I never would have anticipated that. concept, the notion of dark patterns would actually be legislated. And yet here we are. And, you know, it's nothing, it's exactly what you described, right? It's somehow, you know, architecting into the design of your notices and your consumer choice mechanisms, architecting in somehow the influence of, you know, or kind of nudging the consumer to the choice that you want him or her to make. So is anything that, you know, is designed to, you know, manipulate or interfere or subvert or impair a consumer's autonomy over or decision making or choice rights. And it could be even, it doesn't have to be overt, it could be tacit, right? But that's why it's so important for privacy officers to be involved in the development life cycle and configuration of any technologies, right? That's why privacy by design, when you're deploying your solutions, is critically important. So you don't inadvertently violate the dark pattern provisions of these new laws. And it's easier said than done, but yet, you know, it's another challenge and it's another risk that needs to be, you know, inventoried and managed.
So we got, so just the poll results on that first poll, CPRA readiness, 60% have heard of it, but haven't done anything yet to prepare. And the other 40% have heard of it and are actively preparing for it. So it's actually more than I expected that are actually actively preparing for it. So that's a good sign. We have another question from Muhammad. It says, in CPRA, it said that companies can't even share data, not just sell data. How will that impact companies? And then moreover, can you shed more light about service provider mode in CCPA versus CPRA?
I think it's a great question, Mohammed, especially the first one. You know, how do companies impacted by share and sell? For me personally, I've kind of looked at this, you know, working with companies that have tried to comply with both GDPR and CCPA. It's really kind of like a big gap that I've seen, right? I think there's this idea of like, are you selling your data and you're sharing your data? And I think the CPRA actually defines sharing is a big step forward. I think it was in a way almost a loophole to get out of some of the ways of complying with CCPA, because you say, I don't sell my data, but you know, if you go look at, you know, any of the third parties on a company's websites, do they have what we call piggybacking tags, right? Where a tag is calling another tag, which is calling another tag. Do you actually know that, you know, there's profiting that's happening when that's going on? And so I think that impact is actually a good thing, is because it's going to require these companies that have not had to comply to actually come forward and be like, okay, now I'm going to have to disclose the third parties I work with. You know, we're going to talk about making sure that we get consent moving forward. And it really kind of leads to, you know, to what Chris is saying, is you're actually moving from CCPA to CPRA, which is a little bit more of a GDPR type law, not fully GDPR compliant. But it really kind of allows more of that user transparency that we talked about, even to James's first question about, you know, the risk of not being compliant.
Yeah, and I would just add, you know, the reason that the CPRA has included the concept of sharing and the right to opt out of sharing was to clarify the confusion in the CCPA around sale.
Yeah,
there were, you know, if one remembers, there was a lot of mental gymnastics that organizations were going through to in their assessment and analysis of whether or not they sold data, especially within the context of, you know, third-party ad tech on your website. And different companies were coming to different legal determinations. The CPRA tried to clarify that what it meant is, you don't have to necessarily derive monetary value. If organizations are collecting what constitutes personal information or personal data and then passing it along to other organizations, then an individual has a right to know that and the right to make a choice, say yes or no, opt out of it. So that's really the intention of the sharing concept in the CPRA. We can argue about the nuances of a sale versus a share, and that gets into the lawyer's purview. But the intent of including the concept of sharing in the CPRA was to address confusion that arose in the CCPA out of the sale concept.
Great. Yeah, thank you guys. So it is really interesting as we talk about CCPA and what will ultimately replace it in CPRA. So we put up a second poll, and we want to know today, are you complying with CCPA? And if so, how are you? Do you have a consent management solution in place already, a CMP? Do you have a homegrown solution? We see so many brands, enterprises, companies who have tried to comply with CCPA by building and hosting their own kind of in-house solution. Do you have both or neither? So responses are coming in. Some have both. Interesting. Okay. So I think we can move on. Now that we know kind of what CPRA is, how will it affect my company? What kind of changes? And we talked about risk. What kind of changes do we need to put in place? Again, we talked about the risk audits, regulatory fines, some systems catch up, and then obviously the brand risk of not being transparent about upfront data collection is pretty important as well. So what should companies be doing now? What should everyone on this webinar be doing right now? Jeff, I'll let you lead it off.
No, thanks, Chris. Yeah. I think we've covered a little bit of it, right? Let's start with some CCPA compliance. Hopefully you're using some type of method to collect or do not sell, right? Whether it's a CMP or a DSAR. I think that's step one. If you're not using a CMP, obviously it's time to get one in place. I think the draft regulation very much calls that out. And it needs to make sure it's a CMP that can offer a global solution. It's not just California, the CPRA that we're worried about, right? We've got Virginia taking effect, we've got Colorado, Utah, Connecticut, all in line. We've got new bills in Canada, right? So you need to prepare for really a global solution to address any one of your customers. Performing a privacy risk assessment is obviously important. It's called out in those laws. And I think the last one is probably the most important, is identify who you need to collect. Right? It's really easy to have a high level understanding of like the third parties you work with, but if you're not working closely with your marketing team as a privacy team, do you know what third party tags are working with and what third party tags those tags are working with? Right? It's identifying who's on your site and who you need to pass consent to. Because that, obviously, these draft regulations have been very clear about, making sure that your third parties are gathering consent as well about what they're doing on your site.
Yeah.
And I think from there, you're in a good spot. And then obviously, as the law matures, as like what we've seen in like Europe, for instance, when the French regulators make a ruling or whatnot, you're hopefully working with a provider that can pivot on those quickly and make sure that you've got the right technology in place. Because I think Todd, we talked a little bit about this yesterday. There's a couple of facets of what you want to have in place, and technology is probably the most difficult one of those facets to maintain. And it's interesting here in that poll question, because when you talk about a homegrown solution, we all three of us have seen this over the years. There's always been this build versus buy, and now that you've got this complexity of really global privacy law, like I think we've all been talking about it for years. At some point, 80% of citizens will have a privacy law. If you're not specializing in privacy, you're going to have a really hard time, maintaining that presence.
Yeah, Jeff, I agree with everything you said. I would add a couple impressions as well. So, first of all, circling back to the build versus buy question, I am having this conversation almost on a weekly basis with clients, like, should we build or should we buy? And, can you help us with the analysis? And we're constantly engaging at that on that specific question. And sometimes it's appropriate to build, but in the vast majority of cases, what we've seen is that, sometimes, companies can build it better, faster, cheaper in-house, but that's not the issue. The real issue is, how do you maintain it going forward? What's your total cost of ownership? And is this a core service offering that you want to do in-house? And if the answer is yes, then okay. But just recognize that you have to make significant investment, not only to build, but to maintain out over the horizon. That means not only, being able to modify technology for new laws, but being able to ingest material changes to existing laws. And that's very hard. That's why, there's an explosion of investment around consent management platforms such as Dodomi's, right? And others. So there's a lot of good products on the market. I like your product a lot. So it's important to think through the total cost of ownership in going through that build versus buy analysis. But to the second point, Jeff, that you made, which is, your CCPA/CPRA, readiness program, there's really, a few components to it, at least three major components. The first is, once you get your policies and your strategy sorted out, making sure that you have the right people and resources in place, right? And that's, first you have to, your policies and your standards, decide, how you're going to comply and what you're going to comply with. And then make sure you have the resources that can actually do it. The second is, as I mentioned, the processes, making sure that, your workflows are in place. So, as I mentioned earlier, the U.S. has an emerging patchwork of consumer privacy laws coming out of the states, and each one are different. The Virginia approach towards targeted marketing is very different than California's, and so there's not a one size fits all sort of situation in the U.S. And the third is making sure you have the right technology in place. That's a really important component. And as I mentioned earlier, there's a lot of good technologies. Again, as I said, I like Dodomi's technology because you guys are very deep in this is all that you focus on and think about is consent management and how to operationalize it. Mm-hmm. And there's a lot of technological challenges that exist in actually operationalizing a consent management strategy. So that's why it's really important to think through the right technology and get that in place.
Yeah, we've spoken a few times, Todd, about operationalizing privacy and people, process, technology, and really how brands, companies need to rethink their strategy and rethink how they approach doing business around using consumer data going forward. So Really interesting. We have another question from Andy. Do you see federal legislation eventually superseding state law as the newer state laws are diverging pretty significantly from CPRA and GDPR? I know we touched on it a little bit. Right now, the federal ADPPA law is making its way through Congress. I'm personally a little dubious that it will be passed anytime soon, but the fact that they're talking about it is on a bipartisan basis is a huge development. And I think it will. I mean, I think at some point, if it does get passed, that will become the law of the land, and that will supersede all state laws. Todd, Jeff, what do you think?
It's funny we asked this. I actually just saw reading a blog about it yesterday after Google's announcement with the delay of the cookie, and I saw multiple comments that were pretty much saying that the current EDPPA, unless the California House Democrats can see some changes in the law, it's not going to pass the House. I think I probably tend to agree a little bit about that. I tend to be probably a little bit more cynical than some around federal legislation, because I think even outside of state laws, I sometimes wonder if, the U.S. intelligence community is also a stopper, to a federal law, because there's a lot of question about, access to data, like we see with, Shrimps too, and the data transfer pieces. So I think it's to me, it's bigger than just superseding state laws. I think there's a lot more that's going to block it initially than that.
Yeah, Jeff, you raise really good points. I mean, look, I've been desperate for a federal privacy law or data protection law for years, and every couple of years, there's a bill that or legislation that makes a little progress, only to die away. I'm hopeful, but the concept of preemption doesn't mean that the existing state laws or emerging state laws won't continue to be regulatory obligations. We just don't have a clear line of vision on the federal privacy law yet, or legislation yet. I encourage people to contact their internal government relations teams for more insight. But as you said, the whole point of or the benefit of having a federal data protection law will be really to help encourage cross-border trade. It's a trade issue ultimately. And in order to facilitate the digital economy and cross-border trade, we really need to think through what federal legislation should contain. And what it should do is align with the EU and the GDPR in order for us to be designated as adequacy, or an adequate country with the equivalent level of data protection as the GDPR affords EU citizens. If we can obtain adequacy, then that will encourage cross-border trade, and it'll be good for our economy. But one of the difficult things to think through is, of course, the government's access to personal information of citizens. So, it will get resolved, but until that time that, there's political appetite to resolve it at a federal issue, I'm focused on the states.
Very good. Todd, we have a question specifically targeted to you by Paul. He says, Todd, how do you feel about the Name Your Law certification claims by some privacy vendor marketing efforts? Is there such a thing? For example, a certificate of compliance, and what is its longevity?
Tell me more, Paul. Tell me. I'm not sure I understand the question fully. So, Paul, if you can, give a little bit more, granular detail around it, that'd be great.
While Paul does that, there's a pop quiz, so go back to the polls, and we talked a little bit about enforcement and the teeth around enforcement. Does everyone know when the CPRA? We know when it will become effective, but do you know the enforcement date, when it will become enforceable? So go into the polls, answer that, and then we can move on. So we've talked about what is GDPR, how will companies need to start thinking about it, what are the risks associated with it, and then how should we be preparing? We talked about operationalizing privacy, and rethinking how a business operates. And so again, we recommend, obviously, a robust, customizable, flexible global solution like a CMP and a PMP to both process consent-based consumer data and make consumer choice the core of a strategy. We think that's what the market will demand going forward. And then, so this very last slide is just a quick, Virginia is coming on. We haven't spoken really much about Virginia, but Virginia's data privacy law, that becomes effective at the same time as CPRA. So we've actually had some questions around, well, if I'm compliant with GDPR or CCPA or even CPRA, will that make me compliant with Virginia's data privacy law, the VCDPA? I know a lot of acronyms. Jeff, do you want to field that?
Sure. I think it's a great question. I mean, I think it's safe to say if you're compliant with just one, you're not compliant with the others, and I think that's the way you should probably look at it. I think what we see obviously is slight nuances in data. Obviously, between GDPR and CCPA was an opt-out law versus opt-in. CPRA moves us more towards opt-in, but you've got different consent requirements. You've got different types of requirements around your subject access requests, how long you have to fill those requests, how your data is different and categorized, right? What's sensitive in one state or one country or one region will be different from one another. And so it really, really kind of highlights that need of what we talked about a little bit ago about how difficult, how complex this privacy space is becoming, and really trying to manage these types of nuances of each one of these laws.
Yeah, again, I in addition to what you're saying, my answer to that is, I defer to, legal counsel as to, the legal determination whether you're in compliance with all of the laws, if you're in compliance with the CPRA or CCPA. I always counsel our clients that it's important to do an assessment against each law, against each regulation, and map the requirements for each one against your current state of practices. So, for example, the CPRA, if an organization is collecting sensitive information about an individual, the CPRA has an opt-out requirement. You have to provide an individual with the ability to opt out of that data collection and use. Well, Virginia is very different, right? Again, I'm not acting as a lawyer here, but the provisions of the VCDPA say if you're collecting sensitive information about a Virginia resident, then before you can do that, you need to get his or her opt-in consent. So it's really important to make sure that you go through that analysis on a per state basis in order to determine if you are in compliance. One size does not fit all.
Yeah, very, very true. Todd, going back to Paul's question, he clarified it by saying he's had companies ask for a certification of products or services they are considering buying, to your build versus buy comment, CPRA compliant or other, CCPA compliant or other, to which I tell them there is no such thing. What they need to do instead is evaluate each one in conjunction with their privacy office.
I agree with that,
Yeah.
right? And I have been in the privacy software space since 2012, 2011, 2012, around there. It's a long time. And I've yet to see a software company warrant, represent and warrant compliance with any law. It's just not done because there's so many moving parts to technology that to take that on from the vendor side of the table is just an enormous amount of liability, because it all depends on the people, processes that and way that you deploy and use the technology. Technology by itself does not ensure compliant or assure compliance. It is a component and should be part of your compliance program. But you need the right people doing the right things with the right documented processes in place. You got to have all three.
Yeah, it's a good point. I'll just go back to one of the pop quiz. When is the CPRA enforcement date? So about 3/4 of you said January 1st, 2023. That's incorrect. That's when it becomes effective. The enforcement date is actually June 1st of next year. And there was another question from Muhammad. He said, under CPRA, if a publisher/website signals to its downstream ad networks, is there a way to make sure that ad networks do not sell or even share data further? If they continue to sell or share users' data, then who's responsible? Publisher of the website or the ad network?
Woo! The $1 million questions right there. Wow. So look, I am anxious to hear Jeff's answer. Again, talk to counsel. But from where I sit, I always tell my clients, don't be too clever by half. It's I look at this as similar to the way the EU regulators have looked at compliance with both the e-privacy directives and GDPR. It's almost a strict liability sort of approach, which is one back to pat and one throat to choke, right? You're the website operator. It's up to you. You've got the nexus, you've got the connection with the consumer, with the individual. All these third-party intermediaries on the back end, they don't. Right. So ultimately, it's up to you to make sure you're the one doing business with the consumer. They're on your website. It's up to you to make sure that you get the consent, and the consent is managed downstream. That means companies need to have a flexible but an intelligent ad tech governance framework in place. And there's other there's technologies that the industry is developing to help assure or help support with compliance towards consent, and consent being passed down the chain, right? There's the GPC, global privacy consent control. Is that or global privacy control? Excuse me. That was developed by a number of stakeholders. There is, in the U.S., and in fact, the California AG early on mandated that companies should adhere and comply with the GPC, the Global Privacy Control. I don't know how widespread that has been adopted yet, but please note that the AG, I'm sure, is monitoring, and the California Privacy Protection Office is interested in that. Now, the CPRA provides that there's other ways to comply as well, right? You don't have to just rely on that. You can use a consent management platform, etc. But it's important to know that the industry is trying to develop technical standards that will be passed right on down the chain, where organizations on your websites should or must adhere and honor these signals, these opt-out choices.
No, yeah, I agree, Todd. I think, like you said, this is like the $1 billion question. If we could solve this, we'd all be really, really rich. But there's, you could go a lot of, like, you could go down a lot of rabbit holes technologically. If you want to make sure that you're not selling data, then you don't allow the vendors on your site, and there's methods to make sure that when consent is honored and passed, you can just completely block a vendor, period, and that stops the data from being shown or being passed. I think what's more important though, and I think that's an extreme case. Obviously, there's a lot more impacts even beyond that. I think what you need to do is evaluate who you're working with when we go back, when we talk back to like the technological providers. A lot of providers in the market are going to work with certain third parties themselves that are going to develop new frameworks, right? GPC is one of them. We had the TCF, the consent, the transparency control framework in Europe. We've got the GPP that's coming out for IAB North America, and the Canadian consent stream. You've got Google Consent Mode, right? So as you're evaluating your vendors, understand what frameworks they're working with, who they're partnering with, because if you're a Google shop, consent mode's not a bad option, right? It ensures that everything is handled through your tag managers. If you're working with like an Adobe or a Launch, there's methods there as well. And so, that's where that evaluation of that technology is really, really important. And then even taking it a step farther back, knowing who you're working with, right? You can't understand who you're working with if you don't know who you're working with, what data is being passed. And when you get in those privacy impact assessments or those digital impact assessments, don't forget what's on your website and your mobile apps and your connected TVs, because there's ways of discovering that, right? If you can go look through a query string, for instance, and say, hey, is this some data being passed even after a consent? That might be something that you need to look into to say, hey, this is a gap we need to look into. So there's a lot of methods that you can go down to. But I think if you just start with the basis we talked about, knowing your vendors, having the impact assessment, having good technology partners that you're working with, those are all really going to kind of ensure that you're doing the best you can downstream.
Agreed. Yeah, thanks, guys. Does anybody have any additional questions for the panel? There was a final poll. It seems like most of you, without my prompt, and more of a pop quiz again, which is not a new term or concept related to CPRA. The majority understood first party is an existing term, whereas frictionless manner, disproportionate effort, symmetry, and choice are all new terms, new concepts associated with CPRA. So, if nobody has any additional questions or requests, just kind of in closing, in just over 5 months, the most restrictive data privacy legislation in the U.S. Will become effective. It looks like there's maybe one more question. And Tadomi and FTI were purpose built really to help companies understand the environment and help thrive in it. So by all means, reach out to myself, Todd, Jeff, if you'd like to, with any questions, or if you'd like to discuss further. Other than that, thank you all so much for your time and attendance. And we look forward to speaking again. Have a wonderful day.
Thanks, everyone. Bye-bye.
Bye.